yours.
Thank you. Good afternoon. My name is Matthew Oglander, and I'm here from the San Francisco Human Rights Commission, where I'm an investigator and mediator for discrimination complaints. My work focuses on claims involving discrimination in housing, as well as employment, business establishments, and city-funded programs and services. I've been with the Human Rights Commission for a little over 6 years. And one other item I'll mention about my work is that we do provide trainings as requested by housing providers if they have questions about how to comply with various anti-discrimination laws, including reasonable accommodation requirements. That can sometimes also come up as a requirement of settlement for a discrimination complaint. And I want to briefly introduce the Human Rights Commission as well for those who may not be familiar. The Human Rights Commission is a city agency that works to promote equity and eliminate discrimination in San Francisco, and has staff who work on a variety of issues, including providing policy guidance for city leaders and collaboration with other local agencies to improve local policies. As I mentioned in my role, we do investigation and mediation of discrimination complaints. And we have a number of community relations programs that invite engagement with members of the San Francisco communities that we serve. I'll provide some contact information later for anyone who wants to learn more about the Human Rights Commission. To give a guide for the topics I'll be discussing today, we're going to start with the legal framework for reasonable accommodations in housing, and then I will talk about some of the basics and definitions and examples that will help to flesh out that framework. And I will talk about the process that is used to implement reasonable accommodations and modifications in housing. And I will cover some data and trends at the federal and state level, and will provide some resources for more information and more public engagement with city government on these issues. And then at the end, I hope we will have time to address any questions that the members of the council or the audience may have. So, to start with the legal framework for reasonable accommodations in housing, it's worth noting that there are similar protections that exist at the federal and state and local levels. But there are some differences in the definitions and the scope of those protections. And I'll mention a few of those differences. One example is that the Federal Fair Housing Act, which is the main federal law that applies to reasonable accommodations for disability in housing, that law only applies to housing with 4 or more units. So it would not apply to a duplex or a 3-unit building typically. I think it's also worth noting that the Fair Housing Act has design and construction requirements which mandate minimum accessibility features for new housing built since March of 1991. And that's important because, as folks here probably know, San Francisco has a lot of older buildings that do not have accessibility features, and so it's something to keep in mind that as we are seeing more new housing built throughout the city, those are likely to be some of the best properties, most likely to have accessible units and accessible features. And for federal law, it's important to know that enforcement is handled primarily by HUD, which is the U.S. Department of Housing and Urban Development. In addition to the Fair Housing Act, there are some other federal laws worth mentioning. Section 504 of the Rehabilitation Act of 1973 governs federally funded programs and requires those federally funded housing programs to make reasonable accommodations for tenants and applicants. And it's also worth mentioning that the Americans with Disabilities Act, the ADA, does not apply to most housing, certainly not most privately owned housing. The ADA does apply to publicly accessible spaces, such as in a housing complex, if there is a leasing office that is open to the public, the ADA requirements for accessibility to that leasing office may be applicable, but for the tenants who live in that building, the ADA would not be the law that they would file a complaint under. It would be the Fair Housing Act more typically. Continuing with the legal framework, California also has a few important laws that apply to housing. The California Fair Employment and Housing Act covers discrimination based on a large number of characteristics, including disability, as well as many others like race, religion, sexual orientation, gender identity, and many others. And so the Fair Employment and Housing Act, or the FEHA, is an important state law that covers much of the same ground as the federal law, as well as a number of other characteristics. Another state law that applies to housing is called the Unruh Civil Rights Act, and that law prohibits discrimination in all business establishments in California, including housing. And we also have the California Disabled Persons Act, which contains some more specific requirements for non-discrimination in housing, as well as some coverage in other areas. These laws are all primarily enforced by the California Department of Fair Employment and Housing, also known as DFEH. And I'll mention, as I said earlier, federal law is primarily enforced by HUD, and here California law is primarily enforced by DFEH. But individuals who have a claim under either of those laws can also file a lawsuit in court to enforce their rights. At the local level, we have a few laws that apply to housing, and the two that are most relevant for disability accommodations in housing are Article 33, Section 3304 of the Police Code, which prohibits discrimination in housing based on disability, as well as discrimination based on other factors like race, religion, and sexual orientation. We also have San Francisco Administrative Code, Chapter 12C, and that applies to housing run by city and county contractors who receive local funds for that housing program. And the San Francisco Human Rights Commission implements these laws so people can come to us if they have a complaint about discrimination, including failure to make a reasonable accommodation. But one limitation that I think is worth mentioning is that California state law has a pre-emption effect that limits what an agency like the Human Rights Commission can do with complaints involving discrimination based on disability or other factors that are also covered under state law. And so it means that we can investigate and we can try to mediate those kinds of claims, but we do not have enforcement power that would allow us to issue a fine or force the housing provider to do something that they're not willing to do. And so in our work, we often do our investigation and mediation while also advising people of other ways that they may want to enforce their rights through state or federal law. So that's an overview of the legal framework. And now I want to move on to talk a little bit about some basic definitions and concepts that are important to understand with regard to reasonable accommodations and modifications. So the first item is reasonable accommodation. What does that mean? And the basic definition is that a reasonable accommodation in housing is a change in policy, practice, or procedure that gives a person with a disability an equal opportunity to use and enjoy a dwelling. It may be worth mentioning that the laws for reasonable accommodations in housing are similar to the laws for reasonable accommodations in employment. And so courts and administrative agencies often look to examples and precedents from employment cases to help guide interpretation of the requirements for reasonable accommodations in housing. One thing that I think is challenging and important to understand with regard to reasonable accommodations in housing is the tension with the general notion of equal treatment, which is fundamental to most fair housing laws. So when we do trainings for housing providers to help them understand fair housing laws and how to comply with fair housing laws, we usually emphasize very strongly that tenants or applicants cannot be treated differently due to their personal characteristics such as race, religion, sexual orientation, or other similar characteristics. We emphasize that people need to be treated equally. And reasonable accommodations for disability present a different perspective on how fair housing laws apply, because reasonable accommodation laws mean that some tenants or applicants should be treated differently in some situations. They may need to have an exception to a general rule. And that can sometimes be a challenge for housing providers who are trying to treat everyone equally and may have difficulty seeing how they can comply with reasonable accommodation laws that sometimes require different treatment. So I'll mention a few examples of reasonable accommodations in housing. And the first and by far the most common example that we get questions about at the Human Rights Commission is permission to have a service animal or emotional support animal in housing. And so if the building has a no pets policy, then the reasonable accommodation is making an exception to that policy to allow someone to have a support animal. I will also say that service and support animal laws are different for housing as compared to employment or access to business establishments. And so there's a lot of confusion around those differences. And there are a lot of complexities to how service and support animal accommodations are treated. I don't have time to go into much detail. I will just mention briefly that equal access to housing as the goal of reasonable accommodations means that people cannot be punished or put in a worse position because they need an accommodation. And so one of the things that we see commonly is that housing providers may say, we'll allow you to have a service or support animal, but we're going to charge you an extra security deposit, or we're going to charge you extra monthly pet rent as a condition of allowing that accommodation. And those extra charges would not be allowed. That would be essentially punishing someone or charging them in exchange for granting an accommodation. So that's one example of the complexity that can come up. We don't have time to address this issue in full right now. We may be able to answer some questions about that later, but I do want to move on so we can cover the rest of the topics for today. Another example of a reasonable accommodation in housing that we see frequently is addition of a live-in caregiver to assist a tenant with personal care or household chores. And this is something that can be important because a caregiver is not considered part of the household, and that can be important when someone who lives in a subsidized housing situation has their household income counted to determine whether they still qualify for a housing subsidy. And so the person who's living with them, providing care because of their disability, is not considered part of the household, and that person's income is not supposed to be counted as part of the household income. A few more examples that we see frequently of reasonable accommodations in housing include assignment of a reserved accessible parking space if there is a garage or parking lot, transfer to another available housing unit, or a large print application form, or allowing a co-signer on a lease if a person with a disability is unable to work or has limited income due to their disability. Next, I want to cover the concept of reasonable modification, which refers to physical changes to the building, structure, grounds, or facility. And reasonable modification is similar in many ways to reasonable accommodation. The legal framework is mostly the same, but there is an important difference, which is regarding the cost or payment for the modification. And the basic difference is that publicly funded housing requires the housing provider to pay or absorb the costs of the modification. In contrast, privately owned housing does not have that requirement. And so in private housing, the tenant or applicant would be responsible for paying or identifying a source of funding to pay for the modification. A few examples. One that we see commonly for reasonable modifications in housing is installation of grab bars in a bathroom, which may also require reinforcement of the walls to support the grab bars. And again, as I mentioned, the cost is paid by the tenant if it's privately owned housing, or would be paid by the housing provider if it's publicly funded housing. I will also mention at times there are funds available from nonprofit organizations and other sources to help people with disabilities who may not be able to afford to pay for a modification to enable them to get that modification done. And I'll also mention that in addition to paying for the cost of the modification itself, the tenant in private housing is typically required to also put down either a deposit or money in escrow to provide for removal of the accommodation if it is something that might need to be removed after they leave or no longer live in that property. And so that's an issue that can be challenging and it can be complex to determine what is the appropriate amount of money in that situation. Some other common modification examples that we see include lowering the height of counters, cabinets, or other fixtures in the kitchen or bathroom, and installation of a ramp or chairlift, or installation of visual doorbells and visual fire alarms. And again, because these are modifications, these would be situations where the cost is paid by the tenant, except in publicly funded housing. So now that we have some of the basic concepts and the legal framework in mind, I want to move to talking about the process for getting a reasonable accommodation or modification in housing. The process typically needs to start with a request from the tenant or applicant. And that's an important concept that some people struggle with. There may be times when you might think that a particular accommodation or modification is obviously necessary, but the law really sets things up for the housing provider not to assume or guess about what somebody's disability-related needs are. And so the law and the legal framework puts the burden on the tenant or the applicant to make that request to indicate what their disability-related need is. And it's definitely important to note that only a person with a disability is entitled to a reasonable accommodation or reasonable modification. So we'll talk in a moment about what that definition of disability means and how that is verified.
Matt, can I jump in for a second? How much longer do you think your presentation is going to go?
About 5 minutes.
Great. Thank you. Sorry.
And the request for accommodation may be oral or written. Either way is valid under the law, but we strongly recommend that requests be made in writing or by email so that it can be documented clearly if there is ever a dispute about what was requested. And the housing provider may offer a form for tenants to use for requesting an accommodation, but they cannot require that form to be used. They need to accept a request however it may be presented. Once a request is made, the housing provider may request verification of disability-related need for the accommodation or modification unless that need is obvious. And the verification must come from a knowledgeable third party, but it does not need to be a medical doctor. It could be a therapist or nurse or someone else who has relevant knowledge and experience. The verification must confirm that the individual has a disability, but it does not need to specify what that diagnosis or condition is. The verification must explain the relationship or the nexus between the disability and the accommodation that's being requested. I'll mention that a person requesting a reasonable accommodation or modification may choose to disclose the condition or diagnosis, but they're not required to. Regarding the definition of disability, I think it's important to highlight the key difference between federal law, which says that a disability is a physical or mental impairment that substantially limits one or more major life activities. And major life activities include a broad range of things like walking, sleeping, talking, seeing, hearing, working. And California law has a similar definition, but does not require the limitation to be substantial. And so that means that California law protects a much broader range of conditions and impairments under our state law than federal law does. Continuing with the process for accommodations and modifications, it's supposed to be an interactive process. So if there are concerns or questions about the request, both parties need to engage in a good faith interactive process to discuss how to meet the tenant or applicant's disability-related needs. Each side may have information that the other does not, and so it's important to be a dialogue. There are limited reasons for why a housing provider may refuse or deny a request for accommodation or modification. The housing provider generally must grant the request unless it would create an undue financial or administrative burden or fundamental alteration of their services. And it's important to note that every accommodation or modification request must be analyzed on a case-by-case basis to determine if there is an undue burden or fundamental alteration. When we talk about an undue burden, we mean to consider the nature and cost of the accommodation and the financial resources and size of the housing provider and the impact of the accommodation on the housing provider's operations. Delay or inaction, if the housing provider does not respond promptly to an accommodation request, that may be considered a failure to make a reasonable accommodation. But there's not a specific timeline in the law for their response. It's also important to consider alternatives. A housing provider is not necessarily required to provide the accommodation as requested if there is an alternative that would meet the tenant or applicant's needs. One example, as I mentioned earlier, of an accommodation in the application process would be providing a large print copy of an application form. If a housing provider said, our printer's broken, or I don't know how to do that on our computer, but here's another solution. How about I'll ask you the questions and I'll write in the answers for you on the form. That could be an alternative that would accomplish the same goal and would be sufficient to meet the need in that case. I'll quickly mention a few trends that we see in federal and state statistics on housing discrimination. HUD statistics at the federal level show that almost 60% of complaints in the 2017 fiscal year involved disability, and that was up from about 53% in 2013. So disability complaints are clearly a large portion of housing discrimination complaints nationally, and 41% of those involved failure to make reasonable accommodations. At the state level, DFEH has reported in 2017 37% of their housing complaints involved disability, and our local numbers in San Francisco also reflect that disability is commonly one of the most prevalent types of discrimination that is alleged in our local process. For more information, I have a few resources to recommend. First, the San Francisco Human Rights Commission, and our contact information is listed. People can visit our office at 25 Van Ness Avenue on the 8th floor, or visit our website, or give us a phone call. And I do have here listed a resources page for housing-related resources that contains links to a lot of helpful information about housing and disability accommodations as well. In the earlier part of today's meeting, I know there were several questions about some of the local housing programs that are run by the Mayor's Office of Housing and Community Development. And so I do have their contact information here. They're at 1 South Van Ness on the 5th floor. And I'll just briefly mention a couple of things about MOHCD. MOHCD runs the local below market rate housing programs, and the Dahlia portal on their website is the access point for applying for those programs. Those listings typically do identify accessible unit opportunities as well as obstacles to accessibility. One example that I noticed on a recent listing was that units are not ADA accessible because of stairs from the street. And certainly, one of the key concerns for anyone who uses the Dahlia portal is the limited number of housing units that are generally available in the below market rate programs, as well as the limited number of accessible units. But I will just refer back here to the Fair Housing Act design and construction requirements that apply to new housing. And so those mean that any newly constructed buildings should have accessible units according to those requirements. I also think it's important, since there's not someone here from MOHCD, to make sure people are aware of some of the long-range planning that MOHCD is engaged in.
Can I stop you there? We're going to be hearing from them, and I would really like to get to the comments. So rather than have you make their presentation, I think it would be good for us to hear from them.
I appreciate that, and I won't mention any detail. I do just want to point out that starting probably in February, there's going to be some draft plans for the consolidated plan and the analysis of impediments to fair housing choice and the HIV housing plan. And anyone who's interested should check the MOHCD website to see those drafts and how you can submit public comment or participate in that process.
Great.
And last, I do have the contact information here for HUD, which is the federal agency that I mentioned earlier. They provide some very helpful guidance on implementing accommodations and modifications. And the information for DFEH for anyone interested in state law and how they process reasonable accommodation claims. So that's the presentation I have. Thank you very much for your time and attention, and I'm happy to do my best to answer any questions.